Hello everyone, welcome back to the channel. My name is Varun and I am a legal intern at LEXIS and Company. Today we are going to discuss about the topic changing dimensions of patent laws in India. A patent is a proprietary right granted to an invention by a sovereign body. In this video, we will objectively examine India's patent laws and how much they have changed over the years. We began by exploring intellectual property rights and how they have changed. This video reflects on the numerous improvements and modifications made to the Indian Patents Act since it was passed in 1970. The shifting patent laws in India's pharmaceutical industry are also discussed, as well as how productively they have performed in the industry's favor. Economic policy and legislation together regulate a country's socio-economic growth. Part of the explanation for the connection between creation and law is the recognition that without intellectual property rights, civilization will not be able to create science, culture, or creative works at their best. In today's world, the scope of products has expanded to include a broad range of operations covering the whole value chain from raw materials to finished goods. This is why policymakers offer rewards and advantages to inventors while still ensuring that valuable technologies are shielded from being replicated and misinterpreted. Intellectual property refers to the cognitive innovations like inventions, artistic works, and symbols, compositions, names, and pictures that are used in trade. In today's world, intellectual property rights and the security has gained a lot of traction. Since Act 4 of 1856 on the defense of inventions, the world has changed dramatically. The following theories are being established by courts rulings in this digital age: mortal rights, neighboring rights, and author special rights. Furthermore, as the internet has grown in popularity, the threats of music piracy and plagiarism have multiplied, negatively impacting the Indian economy. In the fact that we accept and value intellectual property rights, the defense provided has always been insufficient and debatable. Science, technology, trade, and economic growth have brought unparalleled dynamism to the world, posing unprecedented challenges to India's IPR security regime. The Trade-Related Intellectual Property Rights Agreement, which is administered by the WTO, identifies the current system of intellectual property legislation for all WTO member countries. This has improved India's ability to invest in research and development, specifically in the pharmaceutical industry. Now we will discuss about the patent and laws in India. For a set amount of time, a patent is an exclusive right granted by a country to prohibit anyone from creating, using, or selling a patent invention. The aim of this legislation is to promote innovations by encouraging the preservation and proper application. The Patents Act of 1970, which went into effect on April 20, 1972, was the first step in developing intellectual property rights in independent India. By device patenting, the Act paved the way for reverse engineering. Both member countries were obliged to obey TRIPS agreement clause after the foundation of the World Trade Organization and the subsequent implementation of the Trade-Related Intellectual Property Rights Agreement in 1995. The law stipulated that the product patents be issued for a term of 10 years. On March 22, 2005, India revised its patent laws to satisfy its TRIPS commitments, repealing its method patent law and replacing it with the product patent law. In the years 1999, 2002, and 2005, India's patent laws was revised to satisfy TRIPS arrangement criteria and introduce country-specific adjustments. By January 2005, India had reported in accordance with all TRIPS agreements. Changes occurred in patent laws in India. The Indian Patents Act 1970, as revised by the Patents Act 1999 and the Patents Act 2002, provides the legislative basis for patents. The following are some of the most important changes brought on by these revisions to the original Act of 1970. Number 1. Indians can now apply for patents anywhere in the world with no limitations. Number 2. The word purpose is defined in compliance with the TRIPS agreement and if covers all goods and processes in all fields of technology. Only methods or processes of manufacturing related to food, medicines, and medications were patentable prior to the amendment. Number 3. The list of products that do not qualify as innovation for granted patents has been revised to include TRIPS arrangement exclusions. Previously, an invention could not be patented if its main or desired use was illegal, immoral, or harmful to public health. It would no certainly be viewed as an invention if its main or intended use or industrial exploitation may be in violation of public morals or inflict significant harm to person, animal, or living species, well-being, or the ecosystem, biodiversity, and conventional knowledge security, as well as facts under the non-patentable invention category. Under the amended Act, any living entity or non-living object discovered in existence is not considered an invention. Number 4, As a result of amendments authorizing product trademarks, the patentee's rights have been brought in accordance with the TRIPS agreement's clauses. Number 5. In compliance with the TRIPS deal, reversal of the duty of evidence where a method patent is infringed on has been included. It is now up to the complainant to demonstrate that the device he is using is not the same as the proprietary process supposedly infringed upon. Number 6. Patent terms are now uniformly 20 years as required by TRIPS. Previously, a process patent for food, medication or drug was valid for 5 years from the date of sealing or 7 years from the date of filling, whichever came first, and 14 years from the date of the patent for some other invention. Number 7. The allocation of the right licenses has been withdrawn and compulsory licensing has been brought in line with TRIPS. Number 8. There are provisions allowing the exclusive use of special marketing privileges. There are provisions for the simultaneous import of proprietary materials. In conclusion, intellectual property rights can be described as the rights granted to individuals over their mental creations. In today's information age, intellectual property rights are a vital weapon. It protects developers and other manufacturers of products and services by giving them time-limited freedom to decide how they are used. It is a privilege for writers, inventors, and all other new innovations that may be special to our world. A patent, in return for publishing and encouraging public announcement of the invention, grants the holders the moral right to prevent anyone from creating, using, or selling the invention for a finite period of time. We might infer from this analysis that patent laws have been revised from period to period for proper working and have retained their efficiency not only internationally but also in India. The Indian Patents Act has also been amended multiple times and with required improvements made, especially in the pharmaceutical industry. The changing nature of the country's patent regime and its effect on creativity in the Indian pharmaceutical industry can be seen in this way, which explains why the pharmaceutical industry is one of the world's largest. Also, while this research, I got to know that people in India are less aware of intellectual property rights due to a high level of illiteracy in terms of patents, copyright, and other related issues. It is our obligation to be mindful of these rules, and the government should keep those programs on a daily basis to inform the public. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.